Today, ladies and gentlemen, I want to have a sort of informal talk with you all. I am not going to be a little bit subjective. I propose to just have a random revision with regard to the general principles of the contract we have so far studied. There is a famous guideline which we have got to observe. They used to say, in fact, my guru, my professors used to say, slow, steady, systematic study secures sure success. Rapid revision rarely renders requisite results. So, you must have a study of this entire subject with a sense of aptitude and attitude to improve your knowledge. Most of us are only thinking about facing the examination. I am just giving you a short note of this subject by way of explanation, not with a view to prepare you for the examination, but with a view to just understand it. That is why I don't like people memorizing the sections and then memorizing the case laws and all that. You should understand it. Understanding is something different from just memorizing all these sections and all that. For example, what is a proposal? When one person signifies his willingness to another in respect of doing or abstaining from doing anything with a view to obtaining the assent of the other person to such act or abstinence, he is said to be making a proposal. What is the use of simply cramming it? What is proposal? In fact, I don't like any of these sections being defined in a very complicated way. Proposal is nothing but an idea that is mooted out. It's nothing but communication of an idea. Communication of an idea is what is known as a proposal. An idea will still remain an idea in your mind unless you communicate it verbally. That is why proposal is nothing but communication of an idea by one person requesting the other either to do or not to do an act in order to get the assent of the other person, acceptance. So this is the way you should define. Not that, communication, what you mean, you must be able to convey. What you convey must what you mean. That is why I told you intention, action and willingness, everything should go together. Otherwise there is no consent. Knowingly, feelingly, willingly, that's what I said. So, that is very important. Communication is an asset. Everybody, sometimes there is a slip of the tongue. We must not allow it also. So, in this particular lecture, I would like to just have a rapid general revision with an in-depth study also. So, let us try to clarify some of the doubts that are arising when you study the subject. For example, solvent definition. The law of contract is not the whole law of agreement, nor is it the whole law of obligation. It deals with those agreements which creates obligations and those obligations which have got their source in agreement. Sir, what is it? Just now you said you should not cram the section, cram the definition. Yes, I will simplify it. All contracts are agreements and obligations. All agreements and obligations are not contracts. A question is asked in your examination. What will you reply? Reply is very simple. The law of contract is not going to deal with all types of agreements. What are the other types of agreement? Agreements which surrender rights, agreements which assign rights. Then law of contract is going to talk about what type of agreement? Agreement which creates, defines, protects, preserves rights and obligations. So, these are all the agreements of which the law of contract is going to speak about. The law of contract is not going to talk about social obligations, obligations arising out of a compromise deed, obligation that arises out of a quasi-contract. Quasi-contract is known as implied contract, quasi-contract. So, the obligations you see in Contract Act deals about agreements. What type of agreement? Agreements which creates defines, protects, preserves rights and obligations. So it is only with these types of agreements the law of contract is going to speak about. So that is how you should write. That is, I have given you the hints with which you can develop the subject and then write it. Then the next, pointedly you should write. All bullet points you must give. The next important aspect is, what are the difference between unlawful agreements and illegal agreements and void agreement? What is the difference between void contract, void agreement, unlawful agreement and illegal agreement? See, all illegal agreements are unlawful, but not vice versa. All unlawful agreements are void, but not vice versa. These are generally, they ask the question. See, in order to have a valid contract, CQ plus O, I told you. Sir, what is it you are calculating on the basis of mathematics? No. CQ means C for communication, C for consent, C for consideration. So these are the three C's. That is, all agreements or contracts, if they are made by free consent, for a lawful consideration, for a lawful object. So if, and then by competent parties. See, competent parties, free consent and consideration. If any one of these requirements are absent, there cannot be a contract. But all these things are present. Competent parties are there, free consent is there, and then consideration is there. But yet when the object is unlawful, the entire contract becomes vitiated with unlawful object. Therefore, every contract that is entered upon not only must have all these requirements, but the object must focus for accomplishment of a legal purpose. If the purpose of the contract or the aim of the contract is to do an illegal activity or unlawful activity, well, the contract is vitiated, the contract is invalidated. It is not enforceable by law. All agreements or contract, if they are enforceable by law, an agreement enforceable by law is equal to contract section 2H. So this will not be, will not become enforceable because for lack of ingredients. But even if all these ingredients are there, still if the object is considered to be unlawful, then what is the difference between illegal contract and unlawful contract? First of all, we should say only illegal agreement. Agreement enforceable by law only becomes contract, isn't it? If a particular agreement is illegal, it will be, even at the outset, even at the ab initio, rather even at the beginning itself, the court will find out the illegality and it will declare it as null and void. Ex nudo pacto non retractio, out of a naked pact, no cause of legal action will arise. Impari delicto, poterius conditio, these are all the Latin maxims. See, among two parties who have been equally responsible for any offense, the defense of the defendant position is stronger than that of the plaintiff. So when both the plaintiff and defendants are to be blamed, the position of the defendant is safer than that of the plaintiff. That is what the maximum conveys. So you must see and ensure that the contract that is entered into should not aim for the purpose of committing a crime. An unlawful act is different from committing a crime. As I told you, unlawful act, because there is a Bikani Boy versus Kidalal, where the landlord actually leases out his house on a rental basis, and the tenant is told that he should not actually sublet that particular allotted house. Supposing he subleases it, then is it left open to sublessee for not paying the rent to the head lessee to contend, no, landlord has not allowed you to sublease it, therefore I will not pay you the rent? Can he just take up as a defense? Certainly not. It is for the landlord to question. It is considered to be unlawful only between the landlord and the head lessee not between the head lessee and sublessee. It is not open to the sublessee to cover up his negligence by saying that since landlord has permitted you to sublease the building, I will not pay you the rent. Who is to ask this question? Only the landlord. Who are you? You are only a person who have been let into the possession of this house by way of lease by me. And that too, you cannot deny the title of the person who has let you on the basis of leasing out this house as a tenant. Therefore, you should understand this. So, all illegal agreements are unlawful. But all unlawful agreements need not be illegal, because unlawful agreement will not aim at committing a crime. Illegal agreements are offense under the IPC. The very fact that you have entered into an illegal agreement, it is considered to be an offense. Supposing you enter into an agreement for smuggling gold into India, evading the Customs Act, it is illegal, it is a crime. It is actually, and then money laundering, coffee pizza, conservation of foreign exchange and prevention of smuggling activities. So these are all some of the things which you should bear in mind. It is not a question of just studying law from the point of view of examination. You must have a general knowledge about it. Ignorance of law is no excuse. That is what the maxim says. Therefore, please understand that. So here I told you the difference between this void agreement. What is the difference between void agreement and void contract? Normally that is the question that they ask. Void agreement is an agreement which you enter into agreement with a minor. An agreement with a minor is considered to be void ab initio. Ab initio means what? Right up from the start, right up from the beginning. You cannot even enter into an agreement with a minor. Yes, you cannot. In the sense, minor is not a person. Who is a person under law? I have been telling you, a person under law is one who can enforce his rights against others, and others can enforce their rights against this person. So he is alone considered as a person. An insolvent is not a person. A criminal or a felon under English law is not a person because he has committed crime. Such a person, if he wants to enter into a contract owning huge property, he has got to seek the permission of the court and then enter into an agreement. I told you, as contemplated under the relevant provisions of the Civil Procedure Code. So, these are all the general maxims, general guidelines which you have got to understand. So, that is with regard to the void agreement, unlawful agreement and illegal agreements. That is the question that I have just now discussed. Then the next important thing is, what are all the circumstances under which an offeror can waive means can actually ignore, can waive, can forego, can waive acceptance. Offer is made only with a view to get the assent of the other person. Sir, what is it that you say that an offer can actually waive acceptance? Yes. Merely an offer can be made without any expectation of acceptance to be conveyed to the offeror by the acceptor. What are all the instances under which the offeror can actually waive acceptance? It is a typical case of tacit contract. What is a tacit contract? A tacit contract is a contract that is inferred from the conduct of the parties, isn't it? So, here the offeror simply makes an offer, but he doesn't want the acceptor to convey his acceptance to him. Carlyle versus Carbolic Smoke Ball Company. 100 pounds reward shall be given to anybody whomsoever who uses the smoke ball according to the instructions contained in the leaflet thrice daily for 2 weeks and still contracts the increasing epidemic influenza will be entitled for an award. That is what it says. A sum of 1,000 rupees has been deposited by us with Alliance Bank. These are verbatim the advertisement. So here what you see, the very fact that the person purchases that smoke ball, that is the Vicks vapor rub, is not a ball made out of smoke, but it is Vicks vapor rub, something like that. That is for the purpose of, if you are suffering from severe cold, you can use it as a sort of a remedy. So here, you should understand the very fact that you buy that your conduct, that itself is more than enough. There is no need for you to just take a photograph at the time when you purchase that smoke ball, and then when you are using it, another snap, and when you are sneezing, another snap. Not necessary. Simply it is enough if acceptance need not be even communicated. Very fact. So, these are the circumstances under which an offeror can actually waive acceptance, a tacit contract. Invariably, people actually confuse between the implied contract and tacit contract. A tacit contract is a contract that is inferred by the conduct of the parties. Implied contract means what? Law implies a contract. Law implies a contract means what? Quasi-contract. What is quasi-contract? Implied contract. Certain relation resembling those of contract. So, a quasi-contract is known as implied contract. Example, section 71, finder of the lost goods. One who finds the goods belonging to the other, the law says that he should actually hand over the goods to the rightful owner or give it to the police station. It is what is known as a separate provision under the Civil Procedure Code. That is what is known as interpleader suit. Even in bailment you get. Humorously, I will tell you an illustration. Here is a mother-in-law and daughter-in-law. They are very united. And at that time, when some jewels were actually, when it comes to their possession, both of them actually, they want to actually share the jewel and converting it into bangles. So, they go to the jewelry mart and ask the goldsmith to convert these old jewels into new jewels, and then they want to make bangles, and 6 pair of bangles for the mother-in-law and another 6 pair of bangles for daughter-in-law. This is how they want the gold jewel to be shared. They ask the goldsmith to make it and then keep it ready for them. But after giving those jewels, subsequently when they return home, as you expect, normally there is a storm in the teacup, there is an estrangement between the mother-in-law and daughter-in-law, which is usually the normal way in which life is led in day-to-day family. So what happened? The moment the jeweler actually rang up to this woman that the bangles are ready, then the daughter-in-law informed the jeweler not to hand over the jewel to mother-in-law. Mother-in-law in turn, she said that the jewels should not be handed over to the daughter-in-law. Daughter-in-law versus mother-in-law, mother-in-law versus daughter-in-law, matter went. Then here the question has reached a culminating point where they have gone to the court. Now how the court can decide? Only what suit must be actually filed. You must approach an advocate. Probably they must be able to know that you have got to file an interpleader suit. Section 88 of the CPC and Order 35 of the CPC. An interpleader suit. In an interpleader suit, the person who actually files the suit, that is, he is not interested party. Here is the jeweler has got to file an interpleader suit, in the sense that he will pay only the court fee. That court fee also, the amount which he has spent will be reimbursed by the parties, by the litigants, by the persons who happen to be parties to this litigation. So, under Order 35, according to Section 88, an interpleader suit will be actually filed in the court so as to give the judge the responsibility of deciding who is the owner. Probably we are reminded of Solomon, the famous Solomon, where he decided the real mother, and by giving his judgment that the child must be actually be cut into 2 pieces and 1 piece or so. Then immediately the real mother said, no, don't cut the child. Let the child be with the other woman. So there he actually used his sense, and then he was able to arrive at reason. Like that, in an interpleader suit, it is the judge's responsibility to decide about the ownership of this property and hand over it. So that is why it is said that the judge's duty is to decide as to who is a declaratory suit. Well, that is filed. Interpleader suit is actually filed. That is that. So you must understand that this is another instance where people may actually get doubt and then clarify. It is in bailment also. In the case of joint bailment, it comes. You will be reading it at the time when you read bailment. Then the next important thing is
silence. Will it amount to acceptance? See, silence will amount to acceptance also. People will say, silence does not mean acceptance. Silence, according to the government enactments, you will find, silence also will amount to acceptance. Take, for example, pre-assessment notice issued by the income tax officer or by the sales tax officer. They add a clause in the concluding paragraph. If we do not receive any reply from the assessee or from the recipient within a period of 15 days, we will consider that the recipient has no reply and we will pass the orders accordingly. So this is what is known as the fact where the person does not reply. That means silence. Silence, then they say that it is deemed to have been accepted. So silence will amount to an acceptance. But sometimes silence, mere silence, is considered to be fraud. Scriven versus Hindley. I want to just recollect that case so that you can remember. Here is a person who is selling two varieties of wheat. One is superior wheat, another is inferior wheat. The person who wants to purchase this wheat, he pays the cost meant for superior wheat and take delivery of inferior wheat. At that particular time, can the shopkeeper keep quiet? Yes, sir, you take it, sir. Let us actually make some profit. It is what is known as profiteering. Economics also, so many people do not know the difference between profit and profiteering. What is profiteering? Profiteering is purposely, deliberately making some sort of plan to exploit the consumer and enrich oneself with profit. That is what is known as profiteering. Adding water to milk and then selling the milk is profiteering. So profiting is normal profit. See, that is what is it is said in Scriven versus Hindley. When the consumer purchases, mistaking the inferior quality of wheat to be superior and takes delivery of it and pays the money meant for superior quality, it is the duty of the shopkeeper to break his silence and clarify the consumer. So he should say, sir, you are actually paying money in excess that is meant for superior. No, this is the balance you have got to take. No, do you want superior commodity or inferior commodity? You should say that. Without telling it, where he has got to break his silence. Even silence will amount to fraud. Under what circumstances? Where the shopkeeper has got to clarify certain things to the satisfaction of the consumer. Consumer satisfaction is a very vague term. See, because consumer are of various types. So one person will be actually gives importance to the quality of the product. Another person gives importance to the functioning of the product. Use and throw away. Even if it functions only for 2 or 3 days, it should function efficiently, economically and effectively. But so, you see, it varies. Therefore, here you should understand that this particular aspect, that is what silence. Silence will amount to accept. Again, I have told you, silence cannot be prescribed as a medium of communication. Feldhaus versus Bindley. See, silent cannot be prescribed. If I do not hear anything about the horse, I take it that you have conveyed the horse to me, you have sold the horse to me. How can you prescribe silent as a medium of communication? Communication itself, either by words or by conduct. How can you be silent? So, this aspect also, just try to recapitulate and read well. Then that is that. Then the other thing is, another thing which I wanted to clarify is, a minor during the time of his minority, he executes a promissory note. Then, after becoming a major, he executes another promissory note, because a contract with a minor is said to be void. Let us assume it like this. Supposing a minor has borrowed 5,000 rupees at the time when he happened to be a minor below 18. After completing age of 21, he executes a fresh promissory note
on that particular date. Not acknowledging, he executes a new promissory note, a novation, a new contract. Now, can that promissory note, can it be considered as valid? Money that has been borrowed by the minor as a loan during his minority. There is a check. Minor, it has been given as to the guardian, in the name of minor to the guardian. He has opened an account in the name of the minor. And then, supposing because when it comes to the point of evidence, you have got to prove everything. At the time when the loan that was given to the minor, he happened to be a minor. He was below 18. And subsequently, after becoming a major, can he execute a fresh promissory note in lieu of the loan which has been granted to him during his minority? Here the law says ratification dates back. Ratification. A minor who was not competent at the time of action cannot ratify that action after becoming a major. Ratification dates back. The contract of agency speaks about the various conditions with regard to ratification. Ratification must be made by a person who must be in existence, not merely at the time of ratification, but also at the time of action. Ratification must be made by a competent person who must be competent, not merely at the time of ratification, but also at the time of action. Ratification must be total. It cannot be made in piecemeal fashion. Ratification must be lawful. Ratification may be express or implied. So these are all some of the rules which you find under the General Principles of the Contract Act, Section 186, and so on and so forth. So here you must understand that a minor who has borrowed money during his minority, subsequently after becoming a major, can he execute a promissory note? And that promissory note, whether it is enforceable, certainly not. Because ratification dates back. That is the case which I was referring to. That is the case Indran Ramaswamy versus Antiyappa Chettiar, 1906, 6 MLGA 422. So this is the case law that you find there. Indran Ramaswamy versus Antiyappa Chettiar. So this minor cannot ratify an act after becoming a major in lieu of loan which he has borrowed. That is another thing that you have got to understand. Then the next important thing is consideration need not be adequate, which I have forgotten to tell you. See, consideration need not be adequate. That consideration, even it can be even in the form of very small thing, petty things. See, it all depends upon the appetite of the contracting parties. In fact, I can tell you from Bible, it is more often they cite this example. See, Lord Jesus was born. See, so many people in that particular village, they give lot of gifts for the child as presentation. Very sincerely. See, out of love and affection, they give it. But what happens when a small chirping bird, a tiny bird, when it actually places by bringing the yellow leaf in its beak, and when it places that particular yellow leaf at the feet of Lord Jesus, the child smiles. Here you find consideration need not be adequate. It is love and affection. It is not the presentation that counts. It depends upon the appetite of the contracting parties. So you find that consideration need not be adequate. I may sell my car, which is worth about ₹1,00,000 for say about 30,000 rupees to my friend. Here, out of friendship, I can give. Consideration should not be actually measured in terms of rupees and as pice. It should be valued on the face of it. It represents the love and affection. You cannot actually consider a person when he actually makes a luxurious presentation to you. You should give him a better treatment than a fellow who actually gives you a very petty thing. See, love and affection has absolutely no measuring rod. I am sorry, I am telling you in Tamil. Anbitkum undo adakkumdal arvalar pungannir poosal darum. See, love cannot be measured in terms of rupees and as pice. It is out of the appetite of the contracting parties, they give it. So, see that there is a lot. That is why we said love and affection is adequate consideration where there is an agreement between parties standing in nearest relationship with each other based on natural love and affection need not be supported by consideration. Section 25, subclass 1. So you find this is what you should understand. So consideration need not be adequate, but inadequacy of consideration will give room for verification whether consent has been real or not. Now I will tell you a small illustration. I am wearing a golden ring. A good friend of mine comes and says, Srinivasan, this ring, you see, I want to examine the diamond. This is an American diamond, this is not worth of it. See, where did you buy it? You see, this ring is not worth the diamond on which the diamond which has been fixed on it. So he actually bargains, said, this is not a good, you give it to me, I will take it. See, nobody will actually take it even for 1,000 rupees. Anyway, I will give you 3,000 rupees, you take it. And he takes it. Then I find the next moment afterwards when I come across one of my good friends, that fellow is wearing the identical ring which have been worn by me. Then I ask him, what is the ring which you have got? Yes, sir, I have actually purchased it from so-and-so. That so-and-so is no other than the person who actually bargained with me and purchased it for a paltry sum, the ring which I was actually wearing. Then he says, for how much? Sir, this is a wonderful ring, sir. The diamond which has been fixed in the ring is Kohinoor diamond. It is part of the Kohinoor diamond. It is worth about 10,000 rupees. That fellow who, more than 10,000, he says, it is nearly about 30,000 rupees for which I bought. Then you see, here is, I find that fellow has paid me a paltry sum of 3,000 rupees and he has sold it for 30,000 rupees. See, consideration need not be adequate, but inadequacy of consideration. That is why even if you want to purchase a land, the registrar's office actually sees the parameters. What is the value of this land on which you have got to pay the stamp duty? The stamp duty at the time of registration of any sale deed, you have got to pay the stamp duty according to the value, market value of the property. So the market value of the property, it cannot be fixed arbitrarily by the parties to the agreement, sale agreement. I mean sale deed. In fact, I will rather want to tell you even a sort of a legal advice. You should not enter into an agreement for selling any piece of land. Don't enter into an agreement for sale of any house or property. If you enter into an agreement to sell, you cannot dispose of the property to anybody who offers a better price. Because the fellow with whom you have entered into an agreement, sale agreement, that fellow will say, having entered into an agreement to sell this property, how can you sell it to somebody else? Straight away, it is better to finalize a contract of sale transaction, rather than enter into an agreement to sell and then subsequently executing a sale deed, which is really, it leads to a lot of complications. Straight away, any deal must be direct. There should not be any agreement that before the execution of a sale deed. That is what I would rather advise. So here, what I have been suggesting is that consideration need not be adequate, but inadequacy of consideration. When a land which is worth about 20 lakhs, when it is sold for 6 lakhs, in order to evade a payment of stamp duty, definitely the registrar can question it. It can actually be, the issue can actually crop up. The income tax official will not keep quiet. They will also actually spread their net so as to find out the follies that has been committed by the parties to this particular sales transaction. Therefore, consideration need not be adequate, but inadequacy of consideration will give room for verification whether consent has been real or not. That is another thing that you have got. Thomas versus Thomas. That is the case. In that particular case, Thomas was appointed as an executor for a huge estate worth about crores of rupees. And then that particular estate was given to the mother of the children by way of rent on a meager sum of 1,000 rupees per month. A huge estate. How can they give it for a rent of 1,000 rupees? Then when the matter went up to court, court said consideration need not be. It is out of love and affection. To whom they have given this particular land? This land has been given by way of lease only to their mother. To whom else they can give for 1,000 rupees by way of as a token?
So, this you must understand, consideration need not be adequate. Then the next important thing which I want to just discuss is about joint liability and several liability. So far as performance is concerned, where we have spoken about joint liability, and see, there is always, even in civil procedure code, there is a lot of misunderstanding. There is misjoinder and wrong. See, when a wrong person, see, non-joinder and misjoinder. Let me put it very clearly. A suit is considered to be bad for non-joinder. This comes also under our Contract Act, section 44, 43 and all that. See, supposing there are two creditors. Yes, just illustration, imagine. There are two creditors, A and B. There is a debtor C. The debtor has borrowed the money from these two brothers A and B. A sum of rupees, say 50,000 rupees he has borrowed. Now, when this fellow has got to repay the loan, when he does not repay the loan, both the brothers must file a suit. A and B should file a suit. Instead of A and B together, A alone files a suit against C. A and B have jointly, they have actually lent the money towards loan to C. But here what happens? A alone files a suit. Whether the suit is valid? Certainly not. The suit is bad for non-joinder. A cannot actually file a suit. In limine suit will be dismissed because the promissory note has been executed in favor of both A and B. Therefore, A alone cannot file a suit. If B has expired, the legal representatives of B along with A should file a suit. If A has expired, the legal representatives of both A and the legal representatives of B should file a suit. It can be filed, they can file a suit in a representative manner. So, this you must understand. See, so far as India is concerned, be thorough with this principle. Any liability is considered to be a joint and several liability, so far as India is concerned. In India, a joint liability is considered as joint and several liability, even though you mention it as a joint liability. So far as English law is concerned, joint liability is completely different from that of joint and several. In the case of joint liability, the liability devolves under survivorship. What is survivorship, sir? I do not understand. See, A, B and C, they are the people who have borrowed money jointly from X. So, what happens? X has got to file a suit when these three people have not repaid the money. Jointly they have borrowed. Now, in this case, when A dies, the legal representatives of A will not be liable because the liability survives, rather descends by survivorship. It devolves by survivorship. So what happens? Supposing A, B and C, they have borrowed 3,000 rupees. A has expired. Then what happens? B and C will be liable to pay each 1,500 rupees each. Jointly they should pay, they will actually get subrogated and so on and so forth. So here, B and C. Supposing B also dies, C alone has got to pay the entire 3,000 rupees. Supposing C also dies, the legal representatives of C alone are liable. That is what is known as joint liability. In joint and several liability, under English law, if mention is made about joint and several liability, then in that particular case alone, when A dies, the legal representatives of A along with B and C will be liable. If B dies, the legal representatives of A along with the legal representatives of B will be liable with C. If C also dies, all the legal representatives of A, B and C will be liable. This is what is known as joint and several liability. So that you must understand.